Well, hello and welcome to this IFG Live event, State Aid, a Deal Breaker for the UK. I'm Thomas Pope, a Senior Economist at the Institute and a co-author of our recent report, Beyond State Aid, which looked at the UK's options for subsidy control beyond the end of this year. State aid is the EU subsidy control system that restricts what subsidies member states can provide to businesses. It isn't an outright ban on subsidies, and while the UK has only made limited use of subsidies within the rules over the last couple of decades, other member states, such as Germany, have made much more use of them. Broadly, the state aid system is there to prevent harmful subsidies that favour a business or a group of businesses over others in a way that distorts trade and competition. So economy-wide tax breaks are not generally considered state aid, but a grant or a preferential loan to a single business is. The UK has followed and indeed supported state aid rules as a member state. As it leaves the single market at the end of this year, state aid has emerged as a key stumbling block to a UK-EU trade deal. The EU wants the UK to commit to a robust regime like state aid, and in its negotiating mandate earlier this year, proposed that the UK should continue to follow EU rules. The UK, on the other hand, has so far said that it would not accept any binding restrictions on subsidies in the trade agreements, citing other trade agreements the EU has struck, for example, with Canada. A few weeks ago, the government announced that it didn't intend to replace state aid rules at the end of this year, and instead will fall back onto the WTO system. It is also legislating in the Internal Market Bill to provide ministers with power to override Article 10 of the Northern Ireland Protocol, which covers its state aid provisions. But just yesterday, both David Frost and Michael Gove appeared more hopeful. I'm sure we will get onto the significance of what they said on state aid later on today. So why is it that state aid is such a big problem in these negotiations? Why does the government not want to commit to a subsidy control regime? What exactly does that bit of the MI protocol mean? Is a compromise possible? And what might it look like? Well, I'm very fortunate today to be joined by an expert panel to discuss these questions. George Peretz QC is a barrister at Monkton Chambers, has long been an expert in state aid and will, I'm sure, be familiar to many of you. He's a member of the UK State Aid Law Association and was recently a signatory on a letter from experts offering to help the government design its own regime. Ali Renison is head of EU and trade policy at the Institute of Directors and has been a prominent commentator on UK-EU negotiations over the past few years. She's also got into the detail on state aid, helping to change the undertaking in difficulty test under the EU's coronavirus temporary framework earlier this year. So we're delighted that she's on the panel today to provide her insights. And last but certainly not least, I'm joined by James Webber, a partner at the law firm Shearman and Sterling, and a state aid lawyer who has written a number of influential papers on the topic already this year, describing a regime based on WTO principles that would meet the legitimate aspects of the EU's demands for UK subsidy control while protecting both EU and UK independence. He has also prepared a draft subsidy chapter for the EU-UK FTA, reflecting his ideas, which has been published by the UK State Aid Law Association and also adopted by the pro-Brexit think tank Centre for Brexit Policy. Before I go on, let me encourage you all in the audience to please submit your questions through the Q&A function. I'm planning to leave plenty of time to get to those after we cover some grounds with the panel first. So let's get going. And George, if I can come to you first, why is it that state aid is such a big issue for both sides in these negotiations?
Well, I think they're helpful to look at each side separately. On the EU side, I think the position is it's fairly straightforward and really readily understood, and can be put in quite stark and simple terms. The EU is concerned that if there is a free trade agreement with the UK and the UK has no form of subsidy control regime, the UK will be in a position to offer companies, for example, the opportunity to locate in Europe and in a territory with pretty free access, or tariff-free access at any rate, to the EU, while being able to offer very large bungs, to put it crudely, to those companies of a form that EU member states wouldn't be able to offer, because they will remain constrained by EU state aid rules, which will essentially prevent them from offering similar bungs, because, for example, I mean, if Frankfurt offers a bung to a bank to locate in Frankfurt, that will contravene EU state aid rules, because it will, for example, dissuade that bank from locating in Paris. So there's a fundamental asymmetry in the position of the UK and the EU in such an arrangement, and the EU is just not prepared to live with that. And I think politically, we have to understand that that's just not an acceptable political sell by EU politicians to their own voters. That's why I think this is a sometimes put as an existential concern by the EU. It's a fundamental issue which cannot be sort of wished away. On the UK side, it's a bit more difficult to work out what the rationale behind the position is, given in particular that the UK has a history of offering much less in the way of state aid than most other member states do. It's lived fairly comfortably within the state aid regime. There's been very few cases where the UK has run into trouble for giving unlawful aid. Most things that governments have wanted to do have ended up being cleared by the European Commission, and they fall within the state aid regime. State aid regime in some respects has been quite helpful to the Treasury in giving it a reason for resisting demands to sort of rescue failing industries, and that's been quite helpful. There's no articulated objection to accepting a form of subsidy control beyond fairly abstract concerns about sovereignty. The objection that there would have been to the original EU proposals that the UK couldn't live with a situation with a regime dominated by the European Court of Justice has, I think, largely fallen away, because the EU has made it clear it is prepared to move from that somewhat maximalist original position. One gets stories in the newspapers about the UK is concerned that such and such a proposal, funding tech companies, certain types of tax break, would not be possible if there were a subsidy control regime, but none of that is articulated or developed. And most of us who have worked in this area look at these objections and say to ourselves, well, a well-designed system of subsidy which genuinely meets a market failure, which doesn't create enormous and unacceptable distortions of competition and serves a clearly justified public purpose, will in the end get through a well-developed subsidy regime. So what exactly is the problem here? And one's left somewhat concerned that the real problem is that there are those within government who are just concerned by any constraint or scrutiny of decisions in this area, that they find any constraint or scrutiny unacceptable. There have been also some concerns about the impact of state aid on tax policy. Those may have been somewhat assuaged by the recent Apple decision, but it always has been true that state aid rules have an impact on tax. The same can be said of WTO subsidy rules as well, actually. They can affect tax policy. So I think that's a sort of summary of the position, and sort of broadly, it's very easy to understand why it's a big issue for the EU. It's much less easy to understand why it's such an enormous issue for the UK.
That's a really helpful summary. Thank you, George. Ali, if I can come to you next. George mentions that this is a really big issue for the EU, but the UK has pointed to other trade agreements that the EU has signed and said that the subsidy provisions there were much less than what they demanded from a UK-EU deal. Does the UK have a point here that they're being treated quite differently from those other partners?
I mean, I think in this regard, it depends on your starting point of the parameters of how you view the negotiations. Because if you start from the premise that there is a legitimate point in the arguments that the Commission, we assume they're making them in the negotiations because Michel Barnier has made these public references to the degree of sort of basically proximity to a market and its sort of pre-existing integration with a market. I mean, if you stake that as a legitimate starting point, which is very much, I think, in contention to a certain degree, then you can understand sort of the EU's arguments for sort of wanting to go sort of this and further forwards. I think it would be actually more interesting to look at, even though there is a focus on free trade agreements here and sort of standard offerings. Well, if you're going to have something that's based on the WTO's SCM agreement on sort of subsidies and countervailing measures, then you are sort of moving towards more sort of standard areas. I do think that there is a general lack of understanding that when it comes to competition, having a level playing field or as close to a level playing field as possible is a big focus of most trading partners in negotiations. It's just the extent of it. And so if you were to, I think it would be more interesting to look at where the EU is trying or has tried to go with, for example, Switzerland in this area, because there's not an institutional framework. And I think George probably, amongst others, speak to the sort of specific details of that. But it's a much more, I think, lax regime, for example. I don't know if the government necessarily has precedents in mind. And this is where the question becomes, is it more focused on, as was sort of intimated earlier, this is just about making sure that we don't sign up to any binding standards with the EU in this space, or is it about actually what we want to do with those freedoms? And I think you have to answer that question first to know, well, what is considered acceptable by the government. There has been some reference, I think, and it's hard to look at the detail. There's really in most FTAs. Yes, you can argue that there is a direct impact of subsidy rules and how they interconnect with sort of tax arrangements. There isn't that much. For lack of a better phrase, case law, I think, on this. I don't like to use the word law, but in terms of what the WTO sort of dispute panels have engaged on, I don't think there's that much evidence of it. Having said that, particularly in a single market based on sort of the EU's type of legal order, it's enforcement is very important. And I think that perhaps if the EU hadn't come out with its maximalist position, the government would have been minded to. Never say never, but maybe it would have been more minded to come forward with sort of details of its own regime. I do think it's worth remembering, though, that in the Conservative Party manifesto, if we talk about whether there was any sort of hinting of this to come, it explicitly linked, and this may have given the EU pause for thought, which until this point you would have never expected the Conservative Party administration to make subsidy control one of the do or die issues in negotiations over sensible trade continuity or closure as possible. But we do have to remember that there was a point in the Conservative Party's manifesto going into the election last year that talked about explicitly moving away from the EU state aid regime to create, we never really saw that much detail around it, but I think the wording was a sort of rule for public bodies around Buy British, although they seem to link that more with sort of agriculture than anything else. And we do know that sort of public procurement has been a big focus for some of the government's advisors to date. But as George says, I think understanding exactly what it wants or what it doesn't want out of the regime makes it difficult to know whether what its approach in the negotiations is justified or not. Without wishing to preempt the question too much, I think speaking to a lot of businesses, yes, for the EU, for much of the EU actually, this is a do or die issue in terms of the level playing field. It's interesting speaking to some business organizations in other countries, and you ask them about what their approach to the business organizations in those countries, in the member states' approach to the negotiations are. And in some of the bigger member states, you've got people who are worried about trade continuity, but there is a big block who are also worried, particularly in, I think, some of the steel industries, making sure that there is that level playing field. The last thing I would say on that is, and without seeing the detail of the negotiations or a text, although we've seen some discussion about principles that came out, I think, yesterday from David Frost's evidence to the Committee on the Future Relationship with the EU, that there are some, that the government's not trying to sort of cast it off wholesale, that we think and hope that they do want to move towards a more UK-tailored subsidy regime and state aid regime. The question is about enforcement. And the last thing I would say on that is, George mentioned a reference to tax. I think that is something that probably, even though you had the outcome in the case of Apple versus the Commission on this that was more favorable to, certainly less favorable to the Commission, there is that concern about, that was why certainly the government didn't want to remain in lockstep with the EU rules, was the extent to which tax policy would continue to increase, actually. Very often you hear some references to Margaret Vestager's competition brief. She's done a lot of work also around tax avoidance, and so is that starting to move into normative values? So I think that would probably underscore why there would be actual genuine commercial and government nervousness. But it's really a case of not throwing the baby out with the bathwater. I think there's been some considerable surprise that this was one of the issues that we were willing to potentially risk a no-deal outcome over.
Thanks very much, Ali. That is really interesting. James, can I come to you next? So clearly, this has been an area where the government has wanted to stick its flag in the ground, at least to some extent.
Mm-hmm.
The two sides are still quite far apart. Is a landing zone possible? And I know you've outlined one in some detail. Could you give us the broad strokes of that?
Sure.
And perhaps mention whether you think what David Frost was talking about yesterday is consistent with what you proposed.
Yeah, I mean, I think a landing zone definitely is possible. I'm a little bit more critical of the EU's position. I think I'm not sure I fully buy the idea that the EU's motivation for for imposing state aid control on the UK is appropriate or justifiable. Most FTAs don't, including all the ones that the EU has signed thus far, and the one that they were proposing with the US, which have got similar trade volumes as we've got with the UK, did not have subsidy chapters which are anything like what they proposed initially with the UK. And I also think that the EU's starting position was a bit more than maximalist. I mean, I would say the EU starting position was, completely outrageous and probably a breach of the withdrawal agreement, because it was an attempt to try and impose EU law in the UK, which was, directly contrary to a sovereign-to-sovereign trade arrangement. So I think the EU's position, they started so far out that they are going to have to move an enormous distance, I think. And so but the FTA is very strongly in the European Union's interest. It's largely a goods FTA. We don't have significant financial services chapters, we don't believe. We don't have much in the way of other collateral issues the UK is asking for. So it is strongly in the EU's interests, and I can't really see them abandoning an agreement because of state aid and fish, which are the last 2 points we're led to believe. So what does the compromise really look like? Well, I obviously hope that the compromise looks a little bit like the one I've written up, unsurprisingly. So, and what that would imply is, two sort of separate systems, so that the UK system and the existing EU system. And I think we're best served by having standing, so each side being able to participate in the domestic system of the other, and that allows real remedies and legal certainty around subsidy control. And I think the third sort of element, so separate systems standing in each other's systems, the third element would then be the trigger for engaging the provisions of the subsidy chapter of the FTA would have to be something that actually affects trading competition between the two of us. And that is a massive shift for the European Union, whose state aid rules, at least at the level of is it state aid or not, don't really have any regard to effects. And so it creates a fresh problem, a fresh thought problem, which is, well, how would you design this effects or proportionality test? And I think that you can do it in three entirely obvious categories, which you've got things that definitely do, things that definitely don't, and then things that would need to be assessed and measured in the middle. And that assessment and measurement would have to happen within the domestic systems of each party. And then I think the last sort of point within the domestic regimes would be, well, even if you've got an effect, is it justifiable by reference to the public policy goal the subsidy is seeking to achieve? You typically have this problem where a subsidy would generate an anti-competitive effect, but the policy goal pursued by it supersedes or is considered to be more important. I mean, COVID, of course, is an extreme example of that, but very large amounts of state aid are paid because they achieve a regional development goal or they're an environmental goal or such like. So I think you've got to have some sort of balancing, so to say, at the end. And then I think you reach the end of the domestic systems, and you can have appeals from them, etc. But the end of the administrative part of the system. And then if either side is dissatisfied with the outcome it has achieved in the other side's system, really the only real approach you can have is some form of retaliatory tariff, right, structure, because you can't have a DRM, as it's called, a dispute settlement resolution mechanic that supersedes the domestic decision-making processes, because the EU is not prepared to accept that, because it would essentially act as an additional superior layer to the ECJ, which it's not prepared to tolerate. The UK is not offered that either. So that the structure would have to be retaliation and then a DRM system, which we could make work better than SCM, of course, the WTO agreement, which looks at whether tariffs are justified and whether they're proportionate. And that's it. That to me is a landing zone that I think would be a massive advance on any trade agreement the EU has ever signed before, but would allow both systems to remain independent, would not have some of the problems that the current state aid system has. And I think listening to David Frost yesterday, a lot of those themes were coming through. I mean, the ideas are not, he wasn't developing them in his evidence to the committee, but he talked about an administrative system that looked at proportionality, looked at public policy, whether it can be justified by public policy, that's transparent, that generates an incentive effect, right, which would be one of my sort of blacklisted things. You can't give aid if it's not going to achieve anything. So I think, and I hope the UK is moving towards a system like the one I've described, and that would be an excellent outcome for the UK and the EU.
Great, thank you very much for that, James. That was a really comprehensive explanation. George, can I just come to you and get your views on that? I know you've read James's chapter, and do you think that is could be the basis of a compromise?
I don't think any of us are absolutely confident about what the EU is prepared to accept or not to accept, but it seems to me that in principle, if the UK can develop a robust system of subsidy control, that ought to meet the fundamental political problem that I identified right at the outset of this session. It gives the EU politicians something to say to voters, their own domestic industries, who are concerned by an asymmetry. So there isn't an asymmetry because the UK will deal with subsidies of this kind under its own regime, and if for some reason it doesn't, there are things that we can then do. I mean, I think a couple of sort of comments I would add. I mean, first, just a minor point on dispute resolution mechanism. I mean, I agree there are certainly problems with that. I think one probably is some form of retaliation regime. It's got, of course, to be able to deal with services as well. So tariffs, of course, don't help you much with services. So the retaliation may need to take other forms than tariffs. It might be a sort of reduction of the services privileges of one sort or another, depending on what if anything is negotiated, which may not, of course, be that much in terms of services. What I think is also key to the EU, and was, I think, although I haven't actually heard what David Frost has to say, I'm relying on second-hand reports, I haven't had time. I think one thing missing from David Frost's remarks, which I think is from an EU perspective critical, is enforcement and some form of independent regulator. I mean, I think the EU thinks about these things in legal terms. That's, if you like, a sort of the deformation professionnelle of the EU, but it does think like that. And I think it's going to be very hard for it to accept a regime that is not enforceable, so that third parties can't go to court and force government to comply with it. It just simply won't regard that as acceptable, and it will be looking for some form of independent regulator with real powers to say yay or nay. I mean, not necessarily in all cases. Of course, we know that there's a difficulty with state aid measures in the form of primary legislation, because the UK constitution wouldn't allow a regulator to overrule those. I think that would be accepted. but fundamentally the regulator ought to have jurisdiction to say yay or no, nay, and in most cases, at any rate, to strike down subsidies that were found to be outside the scope of the regime. I mean, I think the other aspect of this is, of course, Article 10 of the protocol, the well-known dispute about that. It has always struck me that I think it's a sort of common ground that Article 10 causes a number of problems. I don't think you'll find very many in the state aid community who think it was a great article. It has all sorts of potential, what I think are now known as reach back effects into Great Britain, and its ambit is going to be somewhat uncertain. You also don't want it running in parallel with the domestic UK regime, because that way lies madness. You will have a lot of measures that will fall under both regimes, and as Lady Bracknell might have said, to have one subsidy control regime is a necessity. To have two looks like carelessness. I think you need, what seems to me to be the sensible way of dealing with Article 10 is for the UK to come up with its own proposals and then go to the EU and say, well, Article 10 was there as a to use the traditional term, a backstop. It was there to deal with a situation where there was no FTA and where there was no UK subsidy control mechanism whatsoever. There is going to be an FTA. Here is the UK subsidy regime. You do not need Article 10, or at least you can very, very seriously cut it back in ways that need a bit of thought, to measures that are genuinely, completely inherent to Northern Ireland. But essentially, you can rely on the UK dealing with Northern Ireland issues through its own mechanism. That seems to me to be the sensible way of dealing with Article 10, rather than simply decide you're not going to comply with it because, having thought about it, you don't like what you agreed to, which is the internal market bill approach.
Yeah, and I think it's just worth coming in on that actually on the internal market bill itself, on the white paper, that was sort of the question around enforcement was just one of the immediate ones that was also tossed up in terms of trying to sort of gauge even business sentiment. I mean, there was a lot of widespread support for the aims as conveyed of the internal market bill in terms of trying to, as I would call it, a tidying up exercise post single market to try and give some continuity or legal backing to continuity of trade across the UK. But in terms of understanding who is responsible for enforcement, particularly since this separately common frameworks program is continuing apace, and in terms of the subsidy control, that was the immediate question, was who was going to enforce these measures. And I think that from a commercial perspective, while there is lots of appetite for having a more UK tailored approach to subsidy constraints, speed, enforcement, scope, I think that, what people don't want to see is the minute you start talking about duplicating multiple regimes, the benefit to it starts to, it's a case of diminishing returns at the end of the day.
Yeah.
That's great. Thank you both. And Ali, if I can come back to you, you mentioned earlier what sort of some EU business groups were saying about reaching state aid agreement. What's the view of business within the UK, if, as what George and James have said, seems likely that the UK is going to adopt its own regime, but maybe with a bit more freedom? How does business feel about that?
I think that if you're going to, it's so difficult to talk about it without knowing, there's so many variables that matter. So on the one hand, in terms of the communicating the argument that we want more freedom to be able to intervene, I do think that you're going to find that as an increasingly more popular argument in light of the pandemic. Although, it depends. Are you trying to hold that up to someone else's regime, or is this the EU's sort of counterparty in this effect? Because obviously, the EU's been extremely flexible to the point of, I'm not going to say that they render state aid rules obsolete at all, but they've been extremely flexible with amendments to their temporary framework for state aid. Having said that, if people feel that yes, on the one hand, they want more freedom to be able to intervene, and I think that state aid is one of those behemoths that, at its fundamental core, when explained, there is support for having those kind of predictable rules. And I think that was something that came across earlier, is that's important to have, is that, while there is a desire to sort of simplify and I wouldn't say speed up, but sort of simplify the rules, no one wants to sort of cast them off wholesale, because there is that desire to have predictability on the other side of the transition period. The more that you are sort of tinkering with the rules, the cumulative effect of that can sometimes offset the sort of, how are we gauging whether the regime is more successful in a sense? Is it that speedier decisions are taken? Is it that, you know, more, what are we trying to do? I mean, what are we trying to do here to a certain extent? Because the issue in the past, I think that you could probably lay at the feet of state aid in different forms is sometimes the inflexibility of it, is sometimes, for example, the extent, the scope of it. So we've mentioned sort of the intersection with tax breaks, so to speak, tax arrangements. You know, on the one hand, I think you are seeing, because of the pandemic as an argument, I think businesses are receptive to the desire to have government taking a stronger hand in supporting industry, particularly at the moment. Although we have to be clear that if you were to look at some of the government's support regimes, you know, the coronavirus, the furlough scheme, those are not state aid. So I think the real regimes are the access to finance ones, the sort of government-backed loan schemes. Having said that, it was the more that you can reference something as being the reason that you couldn't, you know, banks were using the argument about the undertaking a difficulty rule, even though it was put there for the right reason. You know, the EU had put that retrospective date in there to identify what company was actually genuinely affected by COVID, as opposed to have being in struggling and difficulty before then. So it was, the reasoning was right, but, you know, it's the inflexibility of it afterwards and the process by which it took to get it changed. Although I would say from our experience, you know, I'm not sure, it wasn't clear the government were at least publicly making this a big thing to change with the EU. Very often, looking at their public statements on this specific issue over the last couple of months, it was, you know, we are bound by the state aid rules, we can't change them. Well, we did end up changing them. We changed the temporary framework, and that's because the EU has been fairly responsive. So, you know, I think businesses are receptive to the idea of government taking a stronger hand in supporting industry right now. But they also inevitably care a lot about the fairness and level playing fields. I think people don't realize that, not just in Europe, but, you know, in terms of, while we have a majority of IOD members who support the argument that government should be able to, particularly for those larger sort of economy critical big businesses, when they get into difficulty, there has been a lot of arguments around, you know, fairness and what, you know, who is getting what, because if you compare some of the support schemes for COVID in this country to other European ones, even, for example, Ireland's temporary wage subsidy scheme picks up everyone. Not necessarily that the UK scheme is seeking not to do that, but the way in which business is structured, if you're a limited company, there have been lots of exceptions to eligibility. And so if you look at other countries, they've been able to pick up a much bigger share of their workforce. And so I think in this country, actually, the last few months, you've seen businesses start to care a lot more about the level playing field. So in terms of wider support, they want more freedom to be able to support industry as needed. But I think the rules for that and having a predictable framework is really important, even if it's not the exact framework at the moment, because that predictability dimension is really important. And particularly the last thing I would say on that is, as a price of a deal, you know, we've asked members earlier in the year about when alignment was still in play, you know, we wanted to make sure that businesses who were, you know, we have a 2/3 to 1 majority in favor of alignment versus prioritizing being able to diverge from the EU. And we wanted to test whether the people who wanted to be able to diverge as their top priority, the people who wanted to align, did they still want to do that, even if it meant aligning to EU rules in competition and sort of health and safety and employment? And only 1 in 10 wanted to disalign off the back of that. So we know that, you know, in terms of the people who were wanting to align, that there is that preference for, they're not bothered about subsidy rules if it risks a deal with the EU. But I think when you start to go into the detailed examples, everyone has a memory of a state aid rule that went against the, not so much went against the UK, but something was chalked up to state aid rules, I should say. Very often, I think things are blamed on state aid rules, sometimes appropriately, sometimes as the reason for not actually asking the EU in the past to clear something. So we do have governments, you know, whether they are conservative or Labour in the past, who I think have been sometimes quick to not take action or intervene, but not wanting to actually go there and try and get the EU to clear it in the first place.
Great, thank you very much, Ali. That's a really good summary. Now, I still have some more questions that I want to ask, but I noticed that a lot of our audience do too. So perhaps I'll move on to audience questions now, and we'll cover some of my other questions through that. I'm going to start with a question from Alexander Rose, who says, should the UK regime have a regulator? If so, what powers should they have? And I'm just going to tie it in with another question from Jill, who says, can the UK give the EU sufficient guarantees on independent enforcement, given the constitutional position of the CMA, ministerial appointments potentially abolished by primary legislation, as you mentioned George. James, perhaps I'll come to you first on that one.
Well, I mean, I think the UK should have an independent regulator. Sorry, the UK should have an independent regulator. And I'm not particularly driven by the EU's requirements in that regard, but like I think that we need it from a union point of view primarily. You know, these issues, state aid and subsidy control has the potential to be very, very what's the word? You know, can create a very strong pulling apart effect disuniting between the nations of the union, and I think that's the most important reason to have an independent regulator that all nations of the United Kingdom can look to as making decisions which are impartial, which are based on evidence and on the effects of particular measures. And you know, we don't have you know, devolved administrations seeking to disunite the kingdom, so to say, by proposing measures which are you know, going to give dairy farmers in the borders areas, you know, a larger milk subsidy than the dairy farmers in Northumbria, and sort of generating that tension. So I think the best way to diffuse that is not through the Treasury and Whitehall, but through an independent regulator. So that's the primary reason to have an independent regulator. The EU, would the EU accept the CMA? I mean, frankly, you know, the CMA is a much more independent and regulator than the Commission is, which, if anyone's ever done a state aid case, you know, it's wildly political as to whether or not proceedings are opened, the type of standard of evidence that you have placed on you to prove that you meet the criteria. I mean, it's an extraordinarily political process. So I think I can't imagine the Commission would have the chutzpah to seriously suggest that the CMA is less independent than they are. That would be a jaw drop moment, I think.
I mean, I think it's. I don't even think we need to speculate. I mean, the Commission did accept when thinking about the old May Northern backstop proposals, which involved an independent UK state aid regulator administering effectively the EU state aid regime as a domestic regime.
Yeah.
And the text of that referred throughout to there being an independent regulator, and it was, I think, understood by everybody that meant the CMA. I mean, the Commission, of course, is very used. DG Comp is very used to dealing with the CMA as a competition authority. So I don't think that was ever going to be an issue. And I think sort of the theoretical points about CMA being appointed by ministers and potentially abolished by primary legislation are of any great concern. I mean, in our system, it's very difficult to see that you're not going to have a CMA appointed by ministers in at least, you know, which UK governments appoint. It's a different question, but members of the CMA are always going to be appointed by one of the UK governments in the plural. So that it's hard to how you get around that. And of course, in UK system, as the Commission is well aware, anything can be changed by primary legislation. So if you're going to create that as a problem, you're generating a problem that, as you know, to be insoluble. So they won't generate it as a problem. I mean, I entirely agree with James, and really that takes us to other parts of the internal market bill as well. There's a real issue about the way in which these issues are impinging on the powers of the devolved government. I think it's now clause 50 of the internal market bill makes subsidy control a reserved matter, which is a matter that the devolved governments are all protesting about because they see the potential for interference in, you know, right across the range of activities that they currently deal with. And it does seem to me, in fact, I've argued for it for years. I remember putting this idea to the Brexit Select Committee as it then was, and being asked about it, unsurprisingly, by Joanna Cherry. It would seem to me that if the CMA is to have a state aid role or any different state aid regulator, it seems to me that the case for having that regulator appointed by all 4 UK governments and not just the Westminster government is actually unanswerable. It would also, of course, make that entity more independent because it would have 4 masters and not just 1.
I think it's also worth remembering that you know, only a few months ago, despite specifically in this subset of the negotiations, the arguments are being made with some trepidation, ironically, about whether actually this is a conservative government that wants to be able to intervene more, rather than this is just about sort of an argument over sort of the sovereignty of the rules. But a few months ago, that the CMA itself sees post-Brexit. I think it was the chief exec who actually said that they saw an upside in taking back control of the decisions and wanting a more active role in scrutinizing. They'll have plenty of other work cut out for them with Brexit as a consequence, which I think leads to the question: will it be a subsidiary of the CMA? If it is an independent regulator and it is the CMA, under what aegis is it? But they, the CMA wants the powers to take on the powers to impose fines on. I wouldn't say that they have necessarily US tech giants in their sights, but I think they want to be as active, if not more of a tough cookie, so to speak, than the Commission was on some of these areas. So. We shouldn't forget that actually the origins of this from a UK standpoint are actually, despite the questions that the government's current approach to this in the negotiations are leading about what is its intent here, the UK still is may see out of Brexit actually a benefit to actually going harder, tougher, and being actually less political than the Commission, but certainly no less robust in its enforcement work.
Right. So another question here from Guitars George says, what work has the UK actually done to develop a robust system? Does anyone actually know? If I can tie this into another question. So if we are to reach a deal with the EU, which presumably will be contingent on the UK having its own regime, what prospect is there of that regime being ready for January when we leave the transition period? And if that's going to be a problem, then what is the interim arrangements going to be? Who wants to take that? George, should I start with you?
Shall I should start? I mean, we were told in March by Michael Gove, giving evidence to the further relationship select committee, that there would be a robust subsidy regime the EU would find acceptable, ready by now. And we were told in June by Bayes in a letter to the House of Lords Select Committee that they were, quote, working apace to develop a regime, quotes, in tandem with the EU negotiations. So far, no sign of it. And I don't think I'm aware of anyone who's been approached for discussions or consultation about that. Indeed, that was one of the reasons why I supported the letter that James and Alex wrote to the Prime Minister the other week, because it seemed to me that it was entirely unclear to us where the proposals had got to, and it also struck us they might well need some help from outside, because a lot of very difficult issues to be thought through, and the experience of practitioners in operating these regimes is likely to be quite important in getting the regime designed properly. I mean, as far as we know, there isn't a regime sitting ready to be produced. I have to say, if there was a regime sitting, something had already to be produced, it would almost certainly have problems in it, because as far as I'm aware, as I said, nobody from outside has seen it, and it's likely to raise some problems. That does, as you say, raise the question as to what happens in the interim. Let's assume that there is a commitment to a state aid, an anti-subsidy regime of some form in the free trade agreement. It's obviously not going to be acceptable to the EU for there to be a period of months while there is no such regime in effect, while we get on with designing ours, which is the current Bayes position as of its 9th September pronouncement. Something's got to be done in the interim. I mean, it doesn't seem to me that there is much alternative to the one put forward in the IFG paper, which is to pick up the Theresa May government statutory instrument on state aid, which was designed to keep the state aid regime operational in a no-deal situation, and run with that for a bit. The statutory instrument has been drafted. It's sitting there. It had some issues with it, but we can have a look again at those and we can sort them out. But obviously the state aid regime is a known quantity. You're not having to try and reinvent the wheel, and we can just get on with that for as long as it takes to devise a better mousetrap. I have to say, I'm just not sure that there is an alternative solution, actually.
I mean, it's worth mentioning also that statement in terms of following Alex Sharma as the business secretary on that 9th of September sort of outlined that the government would follow sort of WTO rules, that yes, you could make the argument that maybe in certain decisions it can be understand to apply to services, but generally speaking, the WTO rules only largely apply to goods, I would say. So, are we going to have a gap where basically just services aren't covered if we're following that?
Yeah. James, is there anything you want to add?
Well, I think my principal reason for wanting to not have a gap is because I don't think it's sensible for everyone to change horses twice. If we're moving from a state aid the EU state aid rules, which Byzantine as they are understood by those who play in the system, is a bit unfortunate, play in the system. And we are going to move, I hope, to a much better and more efficient and less bureaucratic system. And you'd want to be able to transition between the two rather than sort of have a gap in the middle where no one really quite knows what's going on. So that's my main reason for writing the letter that Alex and I wrote to the Prime Minister, was to try and say, well, look, we have got enough time to introduce everything. And Frost said yesterday that there would be consultation if necessary on the new regime. And that is a little bit worrying, frankly, because to a point George made, Article 10 of the Northern Ireland Protocol, is such a disaster, right, from a state aid UK policy perspective. It's a really vivid example of how badly things can go wrong if you don't make law and policy properly, right? And they've created this dreadful problem for themselves with the protocol, which under any circumstances, the state aid provisions of the protocol, to my mind, just have to go. They're completely unsustainable. So that's what the IM bill is about. They've recognised that reality and they're trying to do it. It's not perhaps the best way of achieving the objective, but the objective is true. You have got to get rid of Article 10, which is ridiculous. But it should be a sobering lesson, I think, in how difficult this policy area is, and we really need, I think, to get the system moving so that we can all see what's proposed and comment on it, and get our shoulders to the wheel so that system comes in as soon as possible.
Great. I have an anonymous question here which builds on that question about the NI protocol. So per the protocol and ramifications of state aid, does the panel think Northern Ireland will come out of this with an advantage or a disadvantage in comparison with GB?
Well, I'll take that. I mean, the state aid provisions of the Northern Ireland Protocol must go. They're unworkable and they must go. So if you're going to have a trade agreement with a state aid chapter, then that is what should replace it. And so you have a UK-wide system with CMA as an independent regulator appointed by all 4 nations, and that's the answer. Right? There isn't a world, in my view, where the Northern Ireland Protocol can stagger on the state aid provisions of it with a separate GB system. I mean, that's George has said you end up with 2 systems. You've got what's the interlinkage between the two, becomes very vexed on all sorts of levels. So I very much hope the government is telling the UK, the EU, whatever it is we agree, Article 10 goes.
It's an interesting question just briefly raised there, because about how the EU sees the protocol, the implementation of the protocol, because there's been so much focus, even though this is probably the most vexing part of it to sort out, there's been so much focus on the internal movements within the UK, and is the government abiding by what it signed up to in the protocol, and the EU's approach from the get-go was to say, I think if the government had come out and even countenanced the possibility that there was going to be any kind of alignment with EU rules in any space in its provisional negotiating text when it sort of sent that out. I think that if they'd left that possibility open, then there you could have sort of reasoned that actually, well, the FTA is just naturally going to pick up a lot of the uncertainties, holes, or I would say inconsistencies in some areas of the protocol. Because they didn't make that commitment, in some areas, it made it a lot easier for the EU to say, well, you're not aligning, we're going to have certain controls, and therefore we need to see your implementation of the protocol in these areas around sort of customs and controls and checks and everything now, because we really can't argue or say or rely on this sort of the argument that the FTA now that we know you're not doing any alignment, is going to pick up some of this. I think the approach is different because all that focus was sort of saying, it doesn't matter what you do in the FTA now, this protocol is going to stand, the exit and summary declarations is going to stand in either direction, no matter what, regardless of what happens with the deal. State aid was a very different beast in that sort. So I'm really intrigued by sort of what James is talking about there. Do both sides recognize that, as opposed to where there is a tension about, do certain obligations around goods movements of the protocol have to be held up regardless of whether there's an FTA? Do both sides actually, is there a consensus that actually that protocol, that part of the protocol in state aid cannot stand on its own and has to be dealt with through the FTA?
I don't think there's a consensus on that at all.
No, I don't think there's a consensus, but I mean, I also think that the point that there are serious difficulties and uncertainties with Article 10, and that it certainly read literally, which is what, as a lawyer, one is supposed at least to start off by doing. It's capable of catching all sorts of measures where the effect on Northern Ireland is either tangential or only a small part of what the measure is about. I mean, that is I think the EU must recognise that there are going to be difficulties in trying to operate that regime, particularly in a situation where there wasn't an FTA and one's trying to operate it in a somewhat hostile environment. And part of the difficulty as well from the EU side is that this isn't a difficulty that can be managed by the Commission taking a, quote, pragmatic or sensible approach to what's caught by Article 10, because Article 10 confers rights on third parties.
Yes, exactly.
And ultimately its scope is to be determined by the European Court of Justice. And also by UK national courts. So if the government did something that contravenes Article 10, the Commission might decide not to do anything about it, but somebody might knock on James or my door and say, James or George, take this case. I want to complain about this. It looks as if it's a breach of Article 10. And we trot off to the national court and we say, this looks like a breach of Article 10. And the national court says, oh, yes, it does. The Commission is nowhere near that, but the national court in those circumstances has no alternative but to strike the measure down or possibly refer it to the European Court of Justice. So this isn't a matter whether, as in various other areas of the protocol, a lot of the problems will be sorted out by the Joint Committee and or the Commission taking a sort of reasonable view and not pushing things. Not this, because it's the thing has been set up and has a life of its own.
Needs to be got rid of.
I think you've made that argument.
Just wait until it intersects with particularly with energy and electricity and the SEM and Northern Ireland's particular interconnections with different actors in that space. Because energy is one of the areas that that state aid is potentially most, shall we call it, flare-upable in. And it's a big contentious issue, and Northern Ireland's a particularly unique arrangement because of its arrangements with GB in this space. So I'm waiting to see how energy sort of factors in with where the arrangements get to on state aid, because I think that's one area that you could see, if it's not worked out properly, stuff popping up almost immediately. Yeah,
well, anyone who was involved in the state aid litigation involving the electricity capacity mechanism, as I was, and I think James may have been, I can't remember, I think almost everybody was in one way or another, will know quite what a mess the state aid rules can make when they go wrong.
Okay, I just want to get through a couple more questions as the end of time. One is more a question of facts, but it's been quite highly voted on the live Q&A. So for those of us less familiar with the details, what has the EU agreed with Switzerland in terms of state aid? Just one of you just wants to take that quite quickly.
I'm not sure I'd say agreed, but George and I have had the discussion just looking about what unilateral measures it rests on, but I'll let George take that.
Okay.
Yeah, I mean, I think that the Swiss are setting up their own, have got to set up their own regime, but it will effectively be EU state aid rules. That's my understanding of it, anyway.
Okay, brilliant. And then one question, and we maybe I'll just get a couple more in, but a few questions asking about what David Frost said yesterday and the principles approach, and whether it would be enough for the UK just to offer a principles approach, or whether there would need to be some more meat in the agreed text. James, can I ask you to?
Well, I very much hope that we can offer much more than a principles approach, and so I hope that we do offer more than a principles approach, frankly. I don't know, everyone's gone, my screen's just changed. So whether it's enough or not, my own view is that the free trade agreement is so strongly in the EU's favour that ultimately, as long as we say something that's more than WTO, then the EU is going to accept it ultimately. Because I think the free trade agreement is so strongly in their interests that that's what they're going to do, and that's what's been shown about the internal market bill sort of fiasco, I suppose, is that they've stayed at the table, and that makes sense. The agreement's very strongly in their interest. So I think if that's all the UK does serve up, then the EU will ultimately swallow it. But I don't think that's necessary. I think we can offer up something that is more concrete, and that will help both us and them.
I guess it rests, I don't know if you have any view on that, James, and certainly George, on to what extent when we talk about enforcement, and are they going to ask expect the details of who is, if there is to be an independent regulator confirming that. But I don't know, whether the EU would be minded enough to accept principles without having clear understanding of how and what or who enforces the principles.
Yeah. I'm a bit more sceptical than James is about whether the EU would accept a set of principles without a commitment to an independent regulator and, ultimately enforcement by the courts and third-party rights. As I said, it does seem, the point I made earlier about the EU does think in legal terms and will expect to see those things as part of a functioning regime. And I suspect, my judgment is that those are critical elements from the EU's point of view. It won't accept what it would regard as fluffy statements of principle. But I also, though, entirely agree with James, and perhaps, this is really the main point, is that that those are elements we should have in our regime anyway, particularly with an eye on the sort of devolution aspects, that one of the principal domestic reasons for introducing such a regime is to prevent the sort of the distortions with which the rest of the internal market bill is concerned. And if that regime is to command confidence across the United Kingdom and in all four nations of the United Kingdom, it's got to have a degree of independence and teeth, and sort of fluffy principles enforced slightly randomly by Westminster politicians just won't work. They won't deliver the regime that's needed.
Just to amplify that, just if it needs to be said, it is not just the EU who wants to have this sort of continuity around third-party rights. In as much as sort of the average business can understand all of the detail of what the state aid regime means currently and what the government is looking at doing it potentially in the future, if you ask them, or you sort of distill the internal market bill sort of in the white paper's aims, and you talk to them about sort of the continuity aspect, one of the first things they ask is, what will will there still be that continuity of third-party rights in any way? Because people want to have access to that at the end of the day. So it's not just something, I think, that, not that in any way that George was suggesting that, but we should just remember it's not just something that the EU wants either.
Well, thank you, everyone. We could keep talking about this for hours, but unfortunately our time is up. So I'd like to thank all of my panelists, George, Ali and James, for a really interesting discussion. And thank you to all of you who were watching along and asking your questions. We managed to get to most of them, or I'm afraid there were a few that we couldn't address. Let me just point you to a couple of other IFG Live events coming over the next few days. Tomorrow we have one on security and Brexit. That's tomorrow morning. That's not one to be missed. And then next Tuesday, I believe, is an event titled Deal or No Deal, which will be looking even more broadly as we reach that 15th of October deadline about whether we expect there to be a deal or not. So thank you all very much for watching.